legal memorandum, and constitutional analysis, subject to constitutional analysis of alleged misuse of public office, conspiracy to effect unlawful possession, deprivation, deprivation of civil rights, and available legal remedies. Part I of Statement of Purpose and Constitutional Foundation. I. Title and Statement of Purpose. Title: Constitutional and Statutory Analysis regarding alleged conspiracy by public officials to effectuate an unlawful deprivation of real and personal property through official coercion, abuse of authority, and violations of federally protected civil rights. Statement of Purpose. This legal memorandum provides an objective analysis of the constitutional, civil, criminal consequences that arise when government officials acting individually, official capacity, or in concert with private parties allegedly deploy state authority, weapons, or official coercion to dispossess an individual of property, liberty, constitutionally protected interests outside of due process of law. This analysis assumes no factual conclusions. Rather, it sets forth the legal frameworks applicable if competent, admissible evidence demonstrates that public officials knowingly facilitated, executed, or failed to prevent an extrajudicial dispossession under colour of law. The core constitutional question is what are the legal consequences when public officials deploy state authority to execute lawful process but to achieve a private dispossession that private parties could not lawfully accomplish on their own. Under American constitutional jurisprudence, the answer is foundational government power is strictly bounded by the Constitution, and no public official, regardless of title or rank, possesses authority superior to the law. Opening statement. This matter transcends a conventional property or possessory dispute. It strikes at the structural core of the constitutional order. The Constitution of the United States was framed on the premise that unchecked executive and police power poses a primary threat to individual freedom. The framers established a system wherein those entrusted with the power to enforce the law are strictly bound by the constraints of the law. Public office is a public trust, not a source of arbitrary privilege. A mayor, sheriff, law enforcement officer, or municipal administrator does not possess innate power to alter legal rights by decree or a show of force. When state power is deployed to deprive an individual of home, property, or physical security without judicial process, private, tortious conduct transforms into a constitutional violation. The law is unequivocal: a citizen's home, possessory property rights, and liberty intra cannot be extinguished through official intimidation, armed presence, or extrajudicial force. They may only be effected through due process, valid judicial order, and strict constitutional safeguards. Executive summary. If admissible evidence confirms that public officials including elected leaders, Mayor Engler, command staff, Captain Matt Young or line officers, Sergeant Welty, Deputies Lopez, Anil, Torres, and Tower conspired with private actors, the Miller household of African Americans, to force an individual from a residence or property through threats, brandishing of weapons, or misuse of colour of law. Such actions extend far beyond routine civil trespass or unlawful detainer. Such conduct directly implicates federal civil rights claims, deprivation of constitutional rights 42 United States Code Section 1983 and civil rights, conspiracy 42 United States Code Section 19085-3 and Section 19086, federal criminal statutes, deprivation of rights under colour of law 18 United States Code Section 242, conspiracy against rights 18 United States Code Section 241, and Hobbs Act extortion 18 United States Code Section 1951. Constitutional violations, infringements of the 4th, 5th, and 14th Amendments to the United States Constitution, state criminal and common law offences, extortion, assault under colour, authority, criminal threats, false imprisonment, official misconduct, and common law trespass/conversion. Fundamental constitutional framework, constitutional provision, core protection, application to official dispossession, 4th Amendment, security in person, house, papers, and effects against unreasonable search/seizure, protects possessory interests in property from extrajudicial star interference or forced removal. Fifth Amendment prohibition against deprivation of life, liberty, or property without due process, mandates pre-deprivation notice and hearing before state-backey property interference. 14th Amendment extends due process and equal protection mandates to state and local actors, binds municipal officials, political and county actors to federal constitutional baselines. Part 2. California Federal Criminal Liability Analysis. I. California Criminal Statutory Violations. A. Extortion and extortion under color of official right. Under California Penal Code Section 518, extortion is the obtaining of property or possessory rights from another with consent induced by wrongful use of force or fear. Under color of official right, Penal Code Section 520 and Section 522, extortion by force or threat, including compelling the signing of documents or surrender of property interests, constitutes a felony. Color of authority when public officials utilize official position, implicit threats of arrest, or police presence to compel surrender of real or personal property. Elements of extortion under color of official right are satisfied. B. Assault, brandishing, and firearms offence. Assault with a firearm, Penal Code Section 245, to displaying or aiming firearms to command submission during an extrajudicial property entry constitutes assault with a deadly weapon. Brandishing a firearm, Penal Code Section 417, drawing or exhibiting a firearm in a threatening manner without lawful justification. Officer acting under color of authority, Penal Code Section 149, penalizes any public officer who, under color of authority, assaults or beats any person without lawful necessity. C. False imprisonment and criminal threats. False imprisonment, Penal Code Section 236, the unlawful violation of the personal liberty of another, restraining an occupant's movement within or preventing entry/exit from their dwelling via armed presence or threat constitutes false imprisonment. Criminal threats, Penal Code Section 422, threatening death or great bodily injury with specific intent to cause reasonable, sustained fear to compel surrender of property. D. Burglary, trespass and official misconduct. Residential burglary, Penal Code Section 459, entering an inhabited dwelling with the intent to commit a felony, including extortion or unlawful conversion. Criminal trespass, Penal Code Section 602, entering real property without consent and refusing to leave, or executing an extrajudicial self-help eviction. Federal Criminal Liability, Federal Criminal Framework, 18 U.S.C., Section 241, 18 U.S.C., Section 242, 18 U.S.C., Section 19051, Conspiracy against rights deprivation under color of law, Hobbs Act, extortion, due plus participant's official status/color of law, obtaining property by fear/force, intentional interference, willful deprivation of rights, misuse of official power. Overt act in furtherance includes possessory rights affecting interstate commerce. A. 18 United States Code Section 241, conspiracy against rights, prohibits two or more persons from conspiring to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any constitutional or federal statutory right. Felony penalties apply, with sentence enhancements up to life imprisonment or death if dangerous weapons are used or bodily injury results. B. 18 United States Code Section 242. Deprivation of rights under color of law makes it a federal crime for any person acting under color of law to willfully deprive an inhabitant of any constitutionally protected right, privilege, or immunity. Public officers who deploy official authority, badges, or weapons to facilitate an extrajudicial eviction fall squarely within the scope of Section 242. C. 18 United States Code Section 19051. The Hobbs Act, extortion under color of official right, prohibits extortion that affects interstate commerce. The Supreme Court has affirmed that extortion under color of official right does not require proof of a specific bribe. It occurs whenever a public official uses their official position to compel surrender of property or valuable rights. Evans v. United States, 504 U.S. 255. D. Limitation on honest services fraud, 18 United States Code Section 1346 under Skling v. United States, 561 U.S. 358 2010. Federal prosecution under honest services wire/mail fraud $S/$1346 is strictly limited to schemes involving bribes or kickbacks. In the absence of direct pecuniary kickbacks or quid pro quo bribery, civil rights criminal provisions 18 United States Code Section 241, 242 represent the correct statutory focus, part of the United States Supreme Court precedent and civil liability. I. Supreme Court jurisprudence on property and state action. A. Seizure of possessory interests. Soldel v. Cook County, 506 U.S. 56 1992. Soldel is controlling on state-assisted property dispossessions. In Soldel, deputy sheriffs assisted a mobile park owner in physically disconnecting and removing a trailer home prior to judicial eviction proceedings. Holding the Fourth Amendment protects possessory interests in property, not merely privacy interests. He rule law enforcement officers who participate in, stand guard over, or facilitate an extrajudicial eviction, execute an unconstitutional seizure, property under the Fourth Amendment, subjecting themselves and their agencies to liability under 42 United States Code Section 1983. B. Procedural due process Fuentes v. Chauvin, 407 U.S. 67 1972 and United States v. James Daniel Good Real Property, 510 U.S. 43 1993. Pre-deprivation hearing mandate except in extraordinary emergency situations. Procedural due process requires notice and a meaningful opportunity to be heard prior to state action that deprives an individual of real or personal property. Extrajudicial self-help and government officers cannot substitute police, coercion, or threats for judicial process, for example unlawful detainer actions or writs of possession. C. Excessive force and colour of authority Graham v. Connor, 490 U.S. 3086 1989 and Screws v. United States, 325 U.S. 91 19045. Objective reasonableness. The deployment of firearms or physical intimidation to execute an unauthorized property clearance fails the Fourth Amendment's objective reasonableness test under Graham. Colour of law. To find that acts performed by officers in the course of their official duties or while clothed with official authority constitute state action, even if acts exceed statutory authority. Screws. Federal Civil Rights Statutory Remedies. A. Civil Rights Act of 1871 42 U.S.C. Section 19083 provides a direct private cause of action against any person who, under colour of state law, subjects a citizen to the deprivation of constitutional rights. Individual capacity officers are personally liable for compensatory and punitive damages. Municipal liability. Monal v. Department of Social Services, 436 U.S. 650-80. Cities and counties are liable under Section 1983 when a constitutional violation was driven by an official policy, custom, unwritten practice, or a decision made by an official with final policy-making authority. A.G. Mayor Engler, Sheriff Matt Young, Chief of Police's negligent supervision and the theory of responded superior. B. Civil Rights Conspiracy 42 U.S.C. Section 19085-3 and 19086. Section 19285-3 imposes civil liability on two or more persons who conspire to deprive any person of equal protection or equal privileges under the law. Section 19286 creates an affirmative statutory duty on public officials who have knowledge of a Section 19285 conspiracy and possess the power to prevent it, imposing personal liability for failure to intervene. For remedies. Relief request. I. The constitutional necessity of effective remedies. The Supreme Court established in Marbury v. Madison, 5 U.S. and Crown Treaty 37 ATT that the very essence of civil liberty consists in the right of every individual to claim protection of the laws whenever he receives an injury, a constitutional right, without an available Enforceable remedy is a legal nullity, where public officials use official power to execute or support an unlawful dispossession. The legal system provides distinct tiers of relief: systemic legal remedies, equitable and injunctive civil damages, criminal and administrative, temporary restraining order compensatory damages, DOJ/DA referral preliminary, injunction punitive damages, internal affairs/code, writ of mandamus section 1938 attorney fees grand jury investigation. Comprehensive tiers of available relief. A. Emergency equitable and injunctive relief. 1. Immediate writ of possession/order of restoration. An immediate mandatory injunction ordering law enforcement and private parties to restore the victim exclusive physical possession of the real property. 2. Temporary restraining orders DRO prohibiting public officials and private co-conspirators from approaching the property, contacting the occupant, utilizing official resources to interfere with quiet enjoyment. 3. Writ of mandamus compelling public officials to perform non-discretionary duties, including processing complaints and ceasing unauthorized police involvement in civil property disputes. B. Civil monetary damages. 1. Compensatory damages recovery for actual financial loss, destruction of personal property, temporary lodging expenses, lost income, physical pain, severe emotional distress resulting from official coercion. 2. Punitive damages awardable under 42 United States Code Section 19-83 against individual officers and officials whose conduct exhibited evil motive, reckless indifference, or callous disregard for federally protected rights. Smith v. Wade, 461 U.S. 33. Statutory attorneys' fees and costs are pursuant to 42 United States Code Section 19-88b. Prevailing plaintiffs in constitutional civil rights litigation are entitled to recover full, reasonable attorneys' fees and expert witness costs. C. Criminal referrals and administrative accountability. 1. Department of Justice and District Attorney referrals of formal submission of investigative packets to the U.S. Department of Justice, Civil Rights Division, and State Attorney General for prosecution under 18 United States Code Section 241. 242 and state criminal statutes. 2. Post and internal affairs oversight administrative complaints seeking decertification of law enforcement credentials through peace officer standards, and training post boards for egregious misconduct and criminal violations under color of authority. Conclusion. The principles governing this analysis are central to the rule of law. Public office is not an instrument for private force, and official power cannot substitute for constitutional due process. When government officials misuse the authority, weapons, and prestige of the state to assist in an extrajudicial dispossession, they violate fundamental constitutional protections guaranteed by the 4th, 5th, and 14th Amendments. The law does not insulate such acts behind public office or official immunity through emergency injunctive relief. Civil rights actions under 42 United States Code Section 19-83, municipal liability under mental, and federal criminal enforcement under 18 United States Code Section 241 and 242. The constitutional order guarantees that those who abuse public authority are held strictly accountable before the court. Part I. Constitutional analysis of alleged abuse of public office, deprivation of civil rights, and the available legal remedies. Title: Legal Memorandum and Constitutional Analysis regarding alleged conspiracy by public officials to effect an unlawful dispossession of property through force, intimidation, abuse of authority, and deprivation of federally protected rights. Statement of purpose. This document presents a legal analysis of the potential constitutional, statutory, civil, and criminal consequences arising from allegations that public officials, say, individually or in coordination with private persons, may have used governmental authority, threats, intimidation, firearms, or other coercive means to deprive individual of lawful possession, property rights, liberty interests, or constitutional protections. This analysis does not presume that any allegation is true. Rather, it addresses the legal consequences if competent and admissible evidence establishes that government officials knowingly participated in, assisted, encouraged, facilitated, or failed to prevent unlawful conduct resulting in the deprivation of constitutional rights. The central question presented is what legal consequences arise when those entrusted with governmental authority allegedly use that authority not to protect constitutional rights but accomplish what private individuals cannot lawfully accomplish on their own. The answer under American constitutional law is clear. Government power is limited by the Constitution, and no public official, regardless of position, title, or authority, is above those limitations. Opening statement. This matter is not merely about a dispute over property possession. It is about the foundation upon which our constitutional system rests. The United States Constitution was created because history demonstrated that unchecked governmental power presents one of the greatest threats to individual liberty. But it is framers understood that a government powerful enough to enforce the law must also be restrained by the law. The Constitution therefore establishes a fundamental principle. Government officials are not the source of individual rights. They are bound by them. A sheriff, a police captain, a government employee exercising public authority does not possess unlimited power. Public office is not a personal privilege. It is a public trust. When governmental authority is allegedly used to deprive a person of property, liberty, security, or constitutional protections without lawful process, the issue is no longer simply private conduct. It becomes a constitutional matter. If evidence establishes that officials acting under cover of law used their positions, authority, resources, or weapons to intimidate, threaten, coerce, or unlawfully dispossess an individual, such conduct may represent precisely the type of governmental abuse the Constitution was designed to prevent. The law recognizes that a citizen's home, property, and liberty interests cannot be taken by force, fear, or official intimidation. They can only be effected through lawful authority, constitutional procedures, and judicial oversight. Executive summary. If credible evidence establishes that public officials, including elected officials, law enforcement supervisors, officers, or other government actors conspired with private individuals to force a person from a residence or property through threats, intimidation, firearms, coercion, or misuse of official authority, the conduct would extend far beyond an ordinary landlord-tenant dispute. Such conduct could implicate California criminal statutes, federal civil rights statutes, constitutional protections under the 4th, 5th, and 14th Amendments, federal criminal statutes involving deprivation of rights under color of law, conspiracy against constitutional rights, extortion through misuse of official authority, public corruption laws, civil remedies for constitutional violations. The critical distinction is this: a private person acting alone has limited power. A public official acting under color of law possesses the authority of the state. When governmental authority is allegedly used as a weapon to accomplish a private objective, the injury is not merely personal. It affects the constitutional relationship between government and the people. The constitutional foundation. The Constitution protects several fundamental interests implicated by allegations of unlawful government action. The 4th Amendment. The 4th Amendment provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The 4th Amendment protects more than privacy. It protects a person's lawful possession and control over property from unreasonable governmental interference. A person's home occupies a uniquely protected position in American constitutional law. The government may not simply decide that an individual should surrender property or possession without lawful authority and constitutional safeguards. The 5th Amendment. The 5th Amendment provides no person shall be deprived of life, liberty, or property without due process of law. The Due Process Clause represents one of the oldest protections in Anglo-American law. It requires that before government deprives a person of a protected interest, the government must provide lawful procedures, notice, and an opportunity to be heard. The Constitution does not permit government officials to replace judicial process with intimidation, threats, or force. The 14th Amendment. The 14th Amendment extends these protections against state and local governments. It provides that no state shall deprive any person of life, liberty, or property without due process of law, or deny any person equal protection of the laws. Local officials, municipal governments, and law enforcement agencies are therefore bound by the same constitutional limitations as the federal government. The constitutional principle at issue, the essential principle, is simple. Government may act only through lawful authority. A government official cannot use public power to accomplish a private objective that would be unlawful if performed by a private citizen. The authority of government comes with a corresponding duty. A police officer's badge does not authorize unlawful force. An elected official's position does not authorize interference with constitutional rights. Government resources cannot lawfully be used to accomplish private retaliation. Public authority cannot be converted into a private enforcement tool. The Supreme Court has repeatedly recognized that constitutional protections exist precisely because government power is capable of causing extraordinary harm when improperly exercised. Constitutional government and accountability. The legitimacy of government depends upon public confidence that officials will exercise power fairly, lawfully, and within constitutional boundaries. When allegations arise that government officials have exceeded those boundaries, the law provides mechanisms for accountability, independent investigation, criminal enforcement where warranted, civil remedies for injured persons, judicial review, injunctive relief to prevent continuing harm. These remedies exist not because the legal system assumes government officials are unlawful, but because the Constitution recognizes a basic reality. All human institutions require legal limits, including government itself. Transition to legal analysis. The remainder of this memorandum examines 1. The potential California criminal offences implicated by the alleged conduct. 2. Federal criminal statutes governing abuse of governmental authority. 3. Supreme Court decisions defining constitutional limits on government action. 4. Civil rights remedies available to individuals harmed by unconstitutional conduct. 5. The legal remedies necessary to restore rights, prevent future violations, and preserve the rule of law. The governing principle throughout is the same. The Constitution does not permit governmental authority to be used as an instrument of fear, intimidation, or unlawful deprivation. Parts all California and federal criminal liability analysis. Introduction. The criminal law recognizes a fundamental distinction between ordinary private disputes and conduct involving the misuse of governmental authority. A disagreement between private parties regarding property, possession, or contractual rights is ordinarily resolved through established civil procedures. Courts provide notice, hearings, evidence, and judicial review. However, when the power of government is allegedly used to bypass those procedures through intimidation, threats, force, firearms, or abuse of official authority, the legal analysis changes dramatically. The issue is no longer simply whether one private party had a legitimate claim to possession. The issue becomes whether governmental authority was unlawfully transformed into a tool of coercion, if supported by admissible evidence. Such conduct may implicate serious violations of California criminal law and federal criminal statutes designed to protect citizens from abuse of power. Potential California criminal violations. A. Extortion and attempted extortion. California law recognizes that extortion occurs when a person obtains or attempts to obtain property or other valuable interests, wrongful use of force or fear. If an individual, acting alone or in coordination with others, uses threats, intimidation, or violence to compel another person to surrender property rights, possession, a leasehold interest, or other lawful interests, the conduct may constitute extortion. Where public officials are alleged to participate, seriousness of the conduct is increased because the alleged coercion is not merely private misconduct, it involves the potential misuse of governmental authority. Potential offences may include extortion, attempted extortion, conspiracy to commit extortion, solicitation or aiding and abetting. Where applicable, the central question for investigators would be whether force, fear, threats, or abuse of authority were used to obtain a result that could not lawfully be obtained through ordinary legal procedures. B. Assault with a firearm and firearm-related offences. The presence or use of a firearm significantly changes the legal analysis. If a firearm is displayed, pointed, brandished, or used to compel compliance, California law provide for criminal liability, depending upon the circumstances. Potential offences may include assault with a firearm, brandishing the firearm, criminal threats, use of a firearm during the commission of another offence, a firearm carried by a government official does not eliminate constitutional restrictions. Law enforcement authority includes the responsibility to use force only when legally justified. A firearm is not a substitute for lawful process. C. Criminal threats. California law prohibits threats of violence intended to place another person in reasonable fear for their safety or the safety of others. If threats were made to force an individual to abandon property, surrender rights, or comply with demands, prosecutors may evaluate whether the statutory elements of criminal are satisfied. The relevant inquiry includes what was communicated, the circumstances in which it was communicated, whether the threat was intended to cause fear, whether the victim reasonably experienced fear as a result. D. False imprisonment. False imprisonment involves the unlawful restraint of another person's freedom of movement. If individuals were prevented from leaving, confined, restrained through threats, or otherwise deprived of freedom without legal authority, the conduct may constitute false imprisonment where firearms, threats, or official authority are involved. The seriousness of the alleged conduct may be substantially increased. E. Kidnapping and aggravated kidnapping. Kidnapping requires additional statutory elements beyond restraint, depending on the facts. Investigators may evaluate unlawful movement, confinement, or transportation occurred through force, fear, or threats. If a person is moved or compelled to relocate against their will, kidnapping statutes may become relevant. The determination depends upon the distance or movement involved, the method used, the intent of the actors, the circumstances surrounding the restraint. Burglary, robbery, theft, trespass, and property offences if property is unlawfully entered, seized, moved, damaged, or retained. Additional California offences may, implicated, depending upon the evidence. Possible offences may include residential burglary, robbery, grand theft, trespass, vandalism, unlawful taking, or retention of property. The key issue is whether the individuals involved acted with lawful authority or instead used force, deception, or intimidation to accomplish a result unavailable through lawful procedures. Federal Criminal Liability. A. 18 U.S.C. Section 241. Conspiracy against rights. Federal law makes it a felony for two or more persons to conspire to injure, oppress, threaten, or intimidate any person, free exercise or enjoyment of rights secured by the Constitution or federal law. A prosecution under Section 241 generally requires proof of 1. An agreement between two or more persons. 2. Intentional interference with federally protected rights. 3. Knowing participation in the unlawful objective. 4. An act committed in furtherance of the conspiracy. The statute exists because constitutional rights are vulnerable not only to individual misconduct, but also to coordinated action when multiple actors allegedly combine their authority, resources, or influence to deprive a person of constitutional protections. Federal law provides a mechanism for accountability. B. 18 U.S.C. Section 242. Deprivation of rights under color of law. Section 242 addresses one of the most serious forms of governmental misconduct, the willful deprivation of constitutional rights by persons acting under color of law. This statute applies when government officials misuse their authority to violate rights protected by the Constitution or federal law. Potential examples include unlawful seizure of property, excessive force, false arrest, unlawful detention, illegal searches, abuse of official authority, intimidation carried out through governmental power. The critical element is that the defendant acted under color of law and willfully deprived the victim of a protected right. A public official does not lose constitutional restrictions simply because the conduct occurs while performing official duties. C. Hobbs Act. Extortion. 18 U.S.C. Section 1951. The Hobbs Act prohibits extortion affecting interstate commerce. The statute defines extortion as obtaining property from another person through actual or threatened force, violence, fear, or wrongful use of official authority. Federal courts have recognized that public officials may violate the Hobbs Act when they use governmental power to obtain benefits improperly, where officials allegedly use their positions to accomplish a private objective through coercion. Investigators may evaluate whether the elements of Hobbs Act extortion are present. D. Honest services fraud, 18 U.S.C. Sections 341 with 343 and with 346 federal honest services fraud laws address corruption involving public officials. However, the Supreme Court placed an important limitation on this statute in Skilling v. United States 561 U.S. 358 2010. The court held that honest services fraud under Section 1346 is limited to schemes involving bribery or kickbacks, a mere conflict of interest or undisclosed self-dealing, without more, is generally insufficient. Therefore, investigators evaluating this theory would look for evidence such payments, gifts, financial benefits, campaign contributions tied to official acts, promises of future benefits, quid pro quo agreements, where such evidence does not exist. Other statutes, particularly sections 241 and 242, may provide the more appropriate legal framework. E. Public corruption and abuse of official authority. Public officials hold positions of trust when allegations involve government officials using public authority for private benefit. Investigators may evaluate potential violations involving public corruption, official misconduct, abuse of office, conflict of interest, conspiracy, obstruction of justice, witness intimidation, evidence tampering, false official statements or reports. The essential question is whether official power was exercised for a legitimate governmental purpose, or whether it was diverted for an improper private objective. Federal investigative considerations. Where allegations involve public officials, investigators would typically examine the full factual record. Relevant evidence may include emails, text messages, telephone records, financial records, campaign records, surveillance footage, body-worn camera recordings, dispatch communications, radio traffic, official reports, witness testimony, property records, court filings, digital evidence. The purpose of such investigation is not merely to determine whether misconduct occurred, but to determine who participated, what authority was used, where there was an agreement, whether constitutional rights were knowingly violated, whether the conduct was official action, or private misconduct disguised as official action. Conclusion: if admissible evidence establishes that public officials knowingly participated in a coordinated effort to deprive an individual of property, liberty, or constitutional rights through force, intimidation, firearms, or abuse of governmental authority, the conduct may have exposed those involved to significant criminal liability under both California and federal law. The law recognizes that the most serious abuses of power occur when those entrusted with authority use that authority against the people they are sworn to protect. For that reason, California and federal law provide criminal statutes specifically designed to address extortion, violence and threats, conspiracy, abuse of official authority, deprivation of civil rights, public corruption. The ultimate determination of criminal liability rests with the appropriate prosecuting authorities after a complete and independent investigation based upon admissible evidence. Part 3. United States Supreme Court Authority and Civil Rights Claims. I. Introduction. The United States Constitution does not merely describe ideals. It establishes enforceable limitations upon governmental power and provides remedies when those limitations are violated. The Supreme Court of the United States has repeatedly recognized that constitutional protections are most important when government authority is exercised against an individual citizen. The central principle is that government officials possess authority because the Constitution grants and limits that authority, not because official power exists independently of constitutional restraints. When public officials allegedly misuse governmental authority to deprive a person of property, liberty, or constitutional rights, the courts have recognized that such conduct may give rise to both federal civil rights claims and constitutional remedies. The following Supreme Court decisions provide the legal foundation for evaluating allegations involving unlawful seizure of property. abuse of official authority, excessive force, conspiracy, municipal liability, and remedies for constitutional violations. Due process of law and protection of property rights. A. Fuentes v. Chevin, 407 U.S. 67 1972 in Fuentes v. Chevin. The Supreme Court held that the Due Process Clause generally requires notice and a meaningful opportunity to be heard before the government deprives a person of a significant property interest. The court recognise that property rights are protected interests under the Constitution and that governmental action affecting those interests must comply with fundamental fairness. The principle, established by Fuentes, is the government cannot simply take or authorise the taking of property without providing constitutionally adequate procedures. Applied to allegations of unlawful dispossession, the constitutional question becomes whether governmental actors bypassed lawful procedures and replaced judicial process with coercion, intimidation, or unauthorized action. B. United States v. James Daniel Good Real Property, 510 U.S. 43 1993 in United States v. James Daniel Good Real Property. The Supreme Court held government generally must provide notice and an opportunity to be heard before seizing real property. The court emphasized the importance of real property protections under the Fifth Amendment. The decision reaffirmed a fundamental constitutional principle. Property cannot be taken simply because the government claims authority. Government must exercise that authority through lawful procedures. This principle is particularly relevant where allegations involve the seizure, loss of possession, or surrender of a home or real property interest. Government participation in property seizure. Soldal v. Cook County, 506 U.S. 56 1992. The Supreme Court's decision in Soldal v. Cook County is one of the most significant cases involving government participation in the removal of a person from property. In Soldal, law enforcement officers were present while a private party removed a family's mobile home from property. The plaintiffs alleged that the officers participated in an unlawful eviction. The Supreme Court unanimously held that the removal home constituted a seizure under the Fourth Amendment. The court rejected the argument that the Fourth Amendment applied only to privacy violations. Instead, the court recognized the Constitution protects possessory interests in property, not merely privacy interests. The importance of Soldal is clear. Government officials cannot avoid constitutional responsibility by characterizing an action as a private dispute when government authority is used to accomplish the deprivation, where officers or officials allegedly lend governmental authority, presence, resources, or coercive power to an unlawful dispossession. Constitutional protections may be implicated. Limits on governmental use of force. A. Graham v. Connor, 490 U.S. 386 1989 in Graham v. Connor. The Supreme Court established the governing standard for claims involving excessive force by law enforcement officers. The court held that claims of excessive force must be analysed under the Fourth Amendment's objective reasonableness standard. The inquiry considers the severity of the alleged conduct, where there was an immediate threat, whether resistance or compliance issues existed, whether the amount of force used was reasonable under the circumstances. The constitutional principle is that governmental force must always be justified. A government official does not possess unlimited authority to use force merely because the official is acting under colour of law. B. Garner, 471 U.S. 19085. In Tennessee v. Garner, the Supreme Court addressed the constitutional limitations on the use of deadly force. The court held that force must be objectively reasonable and cannot be used arbitrarily. Although Garner involved deadly force, the decision reflects a broader constitutional principle. The government may not use physical power in a manner that is excessive, arbitrary, or unrelated to a legitimate governmental purpose. A badge does not eliminate constitutional restrictions. A firearm does not suspend constitutional rights. Public officials acting under colour of law. A. Screws v. United States, 325 U.S. 91 1945 in Screws v. United States. the Supreme Court examined what is now 18 United States Code Section 242, the federal statute prohibiting deprivation of rights under color of law. The court recognized that public officials who intentionally misuse their authority to violate constitutional rights may subject to federal criminal prosecution. The significance of screws is that government authority itself can become the instrument of a constitutional violation. The law does not permit officials to claim immunity simply because they acted while holding public office. B. P. 365 U.S. 1 in 67 19 61 in Monroe v. Hey. The Supreme Court recognized that individuals may seek federal remedies when government officials misuse their authority to violate constitutional rights. The decision became foundational in the development of modern civil rights litigation under 42 United States Code Section 1983. The principle established is a public official who abuses governmental authority may be held accountable in federal court. So municipal liability Monroe v. Department of Social Services 436 U.S. 658 1978 in Monroe. The Supreme Court held that municipalities may be held liable under 40 United States Code Section 1983 when constitutional violations result from official policies, long-standing customs, decisions of final policymakers. However, municipalities are not automatically liable simply because they employ an individual who violated the Constitution. A plaintiff must generally establish that the constitutional injury resulted from governmental policy, practice, custom, or authorized decision-making. The importance of Monroe is that constitutional accountability extends beyond individual actors where institutional practices cause constitutional harm. Federal Civil Rights Conspiracy Griffin v. Breckenridge 403 U.S. 88 1971 in Griffin v. Breckenridge. The Supreme Court recognized that federal law provides remedies against conspiracies that interfere with protected rights, although Griffin involved 42 U.S.C. Section 1985-3. The decision confirms the principle that coordinated efforts to deprive individuals of protected rights may create federal liability. A conspiracy claim generally requires proof of an agreement between participants, a shared and lawful objective, intentional interference with protected rights, acts taken in furtherance of the conspiracy. Honest services fraud and public corruption limitations Skilling v. United States 561 U.S. 358 2010 in Skilling v. United States. The Supreme Court limited the scope of honest services fraud under 18 United States Code Section 1346. The court held that the statute applies to schemes involving bribery or kickbacks. The court rejected broader theories based solely upon undisclosed conflicts of interest or personal self-dealing. Accordingly, where allegations involve public corruption, investigators must examine whether there is evidence of a financial exchange, a benefit provided to an official, a quid pro quo agreement, a corrupt agreement connected to official action, where such evidence is absent. Other statutes, including civil rights and deprivation of rights statutes, may provide the more appropriate legal framework. Qualified immunity and clearly established rights Harlow v. Fitzgerald 457 U.S. 18 to 1982 in Harlow v. Fitzgerald. The Supreme Court established the modern qualified immunity standard applicable to certain civil claims against government officials. Qualified immunity protects officials performing discretionary functions unless they violate clearly established constitutional rights that a reasonable official would have known. However, qualified immunity does not authorize unconstitutional conduct, prevent criminal prosecution, eliminate constitutional protections, create authority, to violate clearly established rights. The doctrine recognizes the need to protect lawful government action, not unlawful abuse of governmental power. Civil rights claims available under federal law. A. 42 U.S.C. Section 1983. Deprivation of constitutional rights Section 1983 provides a civil remedy against persons who, acting under color of state law, deprive individuals of rights secured by the Constitution or federal law. Potential claims may include a unlawful seizure of property, violation of due process, excessive force, false arrest, unlawful detention, retaliation for protected activity, failure to intervene, abuse of official authority. A successful plaintiff may seek damages and equitable relief. B. 42 United States Code sections 19 to 85 and 19 to 86. Civil rights conspiracy, where multiple actors allegedly combine to interfere with federally protected rights. Civil conspiracy remedies may be available where the statutory requirements are satisfied. Section 19 to 86 provides a potential remedy against persons who knowingly fail to prevent violations covered by Section 19 to 85 where they have the ability to do so. Assumption of odds, constitutional principles established by the Supreme Court taken together. These decisions establish several controlling principles. 1. Government officials may not deprive individuals of property without due process of law. 2. Government participation in the unlawful seizure of property may violate the Fourth Amendment. 3. Law enforcement authority is limited by constitutional standards of reasonableness. 4. Public officials who misuse governmental authority may face civil and criminal consequences. 5. Municipal governments may be responsible where unconstitutional conduct results from official policies, customs, or decisions of authorized policymakers. 6. Constitutional rights remain enforceable against every level of government. 7. The existence of public office does not place any person above constitutional accountability. For conclusion, the Supreme Court's decisions establish a consistent constitutional message: a government exists to protect rights, not to override them. The Constitution permits government officials to exercise authority, but only within lawful boundaries. When allegations arise that officials have exceeded those boundaries through force, intimidation, unlawful seizure, or abuse of office, the Constitution provides both limitations on government power and remedies for those harmed. The courts are the institution entrusted with enforcing those limits. The purpose of constitutional remedies is not punishment alone. It is restoration, accountability, deterrence of the rule of law. Government powerful enough to affect the lives and property of its citizens must also be restrained enough to respect their constitutional rights. Remedies. Relief requested. Conclusion. I. Introduction. The purpose of constitutional remedies. The law provides remedies because rights without remedies are merely promises. The Constitution does not recognize the existence of rights, while denying individuals any meaningful method to enforce those rights. From the earliest principles of English common law to the modern civil rights statutes enacted by Congress, the legal system has recognized that unlawful government action must have a lawful remedy where a person suffers harm through the misuse of governmental authority. The purpose of legal remedies is not retaliation. The purpose is restoration, accountability, deterrence, and protection of the constitutional order. If the allegations described in this analysis are established by competent and admissible evidence, the law provides multiple avenues of relief, including criminal investigation and prosecution by appropriate authorities, civil compensation for constitutional and personal injuries, equitable relief to prevent continuing harm, declaratory relief defining legal rights, recovery of litigation expenses where authorized, restoration of property interests where legally available, other relief necessary to protect constitutional rights. Criminal remedies. A. Criminal enforcement by state and federal authorities. Criminal prosecution is the responsibility of governmental authorities, not private individuals, where evidence supports criminal violations. Appropriate prosecuting. Authorities may evaluate whether charges should be pursued under applicable California and federal law. Potential criminal consequences may include prosecution for conspiracy against rights under 18 U.S.C. Section 241, deprivation of rights under color of law under 18 U.S.C. Section 242, extortion under federal or state law, assault with a firearm, criminal threats, false imprisonment, conspiracy, obstruction of justice, witness intimidation, evidence destruction or tampering. Other offences established by the evidence criminal convictions may result in imprisonment, fines, supervised release, restitution where authorized, other criminal penalties imposed by law. The criminal justice system exists to ensure that public authority is not transformed into a means of personal coercion. Civil rights remedies. A. Damages under 42 U.S.C. Section 19083. Congress enacted 42 U.S.C. Section 1983 to provide a federal remedy when individuals acting under care of state law deprive a person of rights secured by the Constitution or federal law. If liability is established, a plaintiff may seek compensation for the full extent of the harm caused. Potential damages may include a loss of property, loss of possession or use of property, damage to personal belongings, physical injury, emotional distress, mental anguish, medical expenses, lost income, loss of earning capacity where proven, other economic and non-economic damages directly caused by the violation. The purpose of compensatory damages is to place the injured person as nearly as possible in the position they would have occupied absent the unlawful conduct. Punitive damages, where individual defendants act with malicious intent, reckless disregard, or deliberate indifference toward constitutional rights. Punitive damages may be available. Supreme Court recognized in Smith v. Wade 461 U.S. 1983 that punitive damages may serve an important purpose in civil rights litigation. Punitive damages are not intended merely to compensate. They serve two additional purposes. 1. To punish particularly wrongful conduct. 2. To deter similar misconduct in the future. Public officials who knowingly misuse governmental authority may face personal accountability when their conduct meets the legal standard for punitive damages. Civil Rights Conspiracy Remedies 42 U.S.C. Section 1985 and 19086, where evidence establishes that multiple individuals acted together for the purpose of depriving a person of protected rights. Federal civil rights conspiracy statutes may provide additional remedies. A successful claim generally requires proof of an agreement among participants, a common unlawful objective, intentional interference with protected rights, act taken in furtherance of that objective. Section 1986 may provide a remedy against persons who knowingly fail to prevent violations where they have the ability and authority to do so. The purpose of these statutes is to address situations where constitutional injuries result not from isolated actions, but from coordinated conduct. Equitable relief and emergency protection. Money damages alone may not adequately remedy constitutional violations. Where continuing harm exists or where there is a threat of future injury, courts may provide equitable relief. Available remedies may include temporary restraining orders. A temporary restraining order may be available when immediate and irreparable harm is demonstrated. Preliminary injunctions. A preliminary injunction may prevent continued unlawful conduct while litigation proceeds. Permanent injunctions. A permanent injunction may prohibit future unconstitutional actions after a final determination. Evidence preservation orders. Courts may order preservation of evidence necessary to ensure a fair proceeding. Restoration of property rights where legally authorized. Courts may order restoration of possession, return of property, or other relief necessary to remedy unlawful deprivation. The purpose of equitable relief is prevention. The law does not require a person to suffer repeated constitutional violations before judicial protection becomes available. Declaratory relief. Federal courts may issue declaratory judgments under 28 U.S.C. Section 2201 2202. Declaratory relief allows courts to formally determine the rights and obligations of the parties. Such relief may establish whether government conduct violated constitutional protections, whether officials exceeded lawful authority, whether a governmental practice or action was unconstitutional. Declaratory judgments serve an important function by clarifying legal rights and preventing future uncertainty. Attorneys' fees and litigation costs. Civil rights enforcement often requires individuals to challenge governmental entities with substantially greater resources. Recognizing this difficulty, Congress enacted 42 U.S.C. Section 1988 which allows prevailing civil rights plaintiffs, in appropriate cases, to recover reasonable attorneys' fees and litigation costs. This provision reflects a fundamental principle: constitutional rights must be practically enforceable, not merely theoretical. Without access to courts and meaningful remedies, constitutional guarantees would lose their force. Preservation of evidence and investigation, because allegations involving public officials often involve governmental records and institutional resources. Preservation of evidence is essential. Relevant evidence may include body-worn camera recordings, dash camera recordings, surveillance video, dispatch recordings, radio communications, CAD logs, telephone records, text messages, emails, photographs, financial records, official reports, court documents, witness statements, medical records, property records. Evidence should be preserved in its original form and maintained through secure backups. The integrity of evidence is essential because accountability depends upon accurate reconstruction of events. Or independent investigation and oversight. When allegations involve senior public officials, elected officials, or law enforcement leadership, independent review may be necessary to maintain public confidence. Depending upon jurisdiction and circumstances, appropriate investigative authorities may include the Federal Bureau of Investigation, the United States Department of Justice, Civil Rights Division, the United States Attorney's Office, the California Department of Justice, the California Attorney General, appropriate oversight bodies, or inspectors general. Independent investigation serves two purposes. First, it protects the integrity of the investigation. Second, it protects public confidence that government institutions are capable of holding themselves accountable. Relief requested. If the evidence establishes that constitutional violations occurred, the following relief may be appropriated. 1. A complete and independent investigation into the alleged conduct. 2. Preservation and review of all relevant evidence. 3. Appropriate criminal review by agencies with lawful jurisdiction. 4. Judicial recognition of any constitutional violations proven. 5th. Compensation for all economic and non-economic damages caused by unlawful conduct. 6. Punitive damages against responsible individuals where legally justified. 7. Injunctive relief preventing future violations. 8. Restoration of property interests or possession where authorized by law. 9. Recovery of attorneys' fees and litigation costs where permitted. 10. Any additional relief necessary to achieve justice and protect constitutional rights. Final conclusion. The Constitution of the United States establishes a simple but enduring principle: government power is legitimate only when exercised within the boundaries of law. Every public official takes an oath to support and defend the Constitution. That oath creates a duty not merely to enforce law, to respect the rights those laws protect. A mayor does not stand above the Constitution. A sheriff does not stand above the Constitution. A police officer does not stand above the Constitution. No badge, title, office, or position of authority creates an exception to constitutional accountability if evidence demonstrates that governmental authority was knowingly used to intimidate, threaten, dispossess, or deprive an individual of constitutional rights. Then the legal system provides the tools necessary to investigate, remedy, and prevent such conduct. The purpose of these remedies is not revenge. It is accountability. It is the restoration of lawful order. It is the protection of the principle that has defined American constitutional government for generations. No person is above the law, and no government official is beyond the reach of the Constitution. The strength of our republic does not depend upon the absence of governmental power. It depends upon the existence of lawful limits on that power, and when those limits are violated, the Constitution provides the means to restore justice.